Yeah, it booted. Well, your mom's here now. We're live again. Hi, Mom. But it'll be up for awards. So. Cut out basically after Lindsay.
When I walked up, I was like, I have to leave. I can't.
I know my mom.
What can your mom see now? Is Scott watching? Is Scott here?
Hey, Scott.
Yeah. But we got the internet back and someone's watching. Back to the most important. I hate it. Do you see it now? Go to the page. Let's see, I have it up for the award. The courthouse Wi-Fi data is off. No, just go clicking. It's working now. You see me? Okay. All right. Sounds good.
Because I know, but I left my paper on the table, and literally when he asked me, she prepared her best. I prepared her best, and I left it on the table. Dude, I literally wrote the whole thing this morning, and I left it on the table, and I'm like, oh, 1 second while I go dress code council. Yeah, but she left the paper that she texted. Dude, I left the paper on the table. I wrote. I know. And I knew best also, but I was like, the Johnson Brinton's about to ask me for a site.
Yeah, that's true.
He would have asked me for a site, like, and I would have been like, ask the other side, they don't know either. It was going to be my brother. I was going to be like, Chief Justice, if you didn't hear opposing counsel, they agree with us. Thank you. Dude, so many people were watching.
Diego negotiated. Diego's whenever Diego like sets his mind to, it's gonna happen and 10 times better. It's like it's so funny. I'm like,
Hi guys, thank you for watching. Oh, the Chief Justice is here.
you wait all that time. Yeah. You want it now. Yeah, I mean.
Does it yeah. We're like, let's be dramatic.
Oh yeah, that's fine. Like literally
Shaw. It says that it's not streaming, it's just showing the video. There's a new link.
That's not true. I was on the phone clocking and she literally watched me on it.
They can hear you.
That's fine. Hello, everyone. Welcome. Nice to meet you.
Oh yeah, that was so bad. Was it bad?
Yeah,
Hey, this is so good. I watched you guys. You guys were really like this was really good. Matt said hi, Sean. Madison said hi, Sean.
Alright. Yeah, I'll do that.
You're talking about Pocket, they were saying that stream wasn't working.
It's like his uncle who's not really his uncle. Your family friend. No, like
Oh, I can see Saul.
Really? Which is like, I would already be so scared, like, you're like the new one.
You're just going back. Bye.
Melissa, are you announcing that? Or I don't know. Ask me first.
All right, welcome back, judges. Before you guys begin, I did want to first give out the award for the best brief before we announce our first and second place. So, for the best brief award for the 2023 Moot Court Winter Intramural Competition, we have Avanya Turan and Kelly I just want to absolutely commend these women because they're absolutely incredible and so smart. And one of the only teams we had where both of them were trying out to get on Moot Court. So this is a no Moody team that won best brief. They're incredible. They are absolutely wonderful and so smart. And congratulations.
And they made top 8. They just couldn't be here.
And then did make top 8.
Well, again, congratulations. Okay.
Congratulations to all of you. I hear you're all on the team and made it this far. That's amazing. Just a couple of quick notes for you guys. I know this is the last of it for you, so it's not really to include in this competition per se, but they're notes that you could take forward with you in the moot court system and moving on. So petitioner 1, Lindsay. I will say, pick your focus, especially with a closed problem. Okay, so when you know that the problem is going to center on hearsay and its exception, and that's your specific portion of the argument, you don't want to sort of take it on tangents of relevance and prejudice, and it kind of confuses the issues and takes focus away from your strongest arguments that you've already prepared for. The issue of demeanor, I would just say, keep it, you are representing the individual, you are the petitioner here for the defendant, but you're also in front of the Supreme Court, so keep it a little bit more formal in your presentation. Petitioner 2, I'm sorry, give me your first name again.
Jordyn.
Jordyn, I thought that you had a very clean, very precise presentation. I would just be very careful about being correct. If you're going to answer a question, a direct question with a direct answer, make sure you're right. If you're not sure, or you haven't researched that issue, or that issue hasn't been briefed, or you don't know, don't act like you do. You're going to lose credibility with the court. Oh, I'm sorry, that was to you. That's the note I had for you. I thought that as a respondent, with regard to the confrontation clause, I think that you did a good job sort of coming back every time the court tried to derail you on the confrontation clause.
This is
Respond.
What's that?
This is respondent.
Yeah, but you had the second part of that argument for the petitioner, did you not?
Oh, yes, sorry.
Okay.
I thought you said responders. I was
I'm sorry. For the petitioner on the confrontation clause, I thought you did a good job. We tried hard to kind of get you off focus, and you brought us back, kept coming back to us, which I thought was good. For the respondents, yeah, you already heard my note, spoiler alert. Okay. The issue of whether or not the tape is testimonial, and your argument went to it has to apply to a specific person. The accused has to match the accused in the statement. I don't know if you're right about that, and you have to be sure you're right before you answer a question so emphatically. And we tried a few softballs on that issue, specifically with the kind of reading it a little broader than that and not so narrowly. And you had a chance to say, well, even if that was the case here, they lose because X, Y, Z. Zagerman, I liked the cites to the record. I thought you had a really good handle on the record and the arguments. Where you lost me specifically was where remedy. You have to be super, super clear on remedy and how your concessions line up with the remedy you're asking for. So the government can't concede that the statement is out, that portion of the statement is out, and also say, we're looking for flat out affirmance. Because that doesn't jive with, well, then how do we know the jury didn't consider it if you're saying that it was wrongly admitted? You have to, if the panel is giving you kind of an out, you have to say, well, Judge, we're seeking affirmance for these reasons. However, Should the court find that this statement was in fact harmful, and or this court is unable to determine whether or not this statement was harmful, we would ask the court to specifically carve out that statement and remand for trial, allowing for the government's admission of the tape at large with redaction. And affirm in part, reverse in part. That you have to be really, really clear, or your concession didn't make any sense. That's why we were like, well, we're the Supreme Court. Are you asking us to reweigh the evidence? We can't do that. A jury's already heard it and decided. We don't know what they talked about back there. So be really clear on that. And but I thought y'all had a really, really good demeanor, really good cadence, really good eye contact, really good confidence. All of you wouldn't be here. That's my 2 cents. Congratulations.
I'm not gonna go person by person. Well, I mean, I think we all kind of sort of had very similar impressions of the arguments, but you all were wonderful. And that's why you're in the final round, is because you all are wonderful at what you do. Just a couple of quick things. In my experience, when the case is called and you get up to the podium, you're starting right away. You're not arranging your papers and this and that, because you don't know who your judges are. You don't know where they're coming from, and they're busy. It's just it's a sort of a respectful thing to do. I thought that everybody's composure, everybody's eye contact was wonderful. Because at the end of the day, as they say, this really is a personal conversation that you're having with the court. I know it doesn't feel like that, I understand that, but it really is. This is your only chance, your client's only chance to talk to the decision makers about the case. So it's very important that you win this over in the personalness as well as the merits of your argument. I particularly liked when you were asked questions, all of you, that you got back to where you wanted to be, and even more so, you want to keep doing that because you have a limited amount of time, and it's easy to get distracted into something that is not before the court. And so I commend you for doing that. I guess what's important to me is, I think we all ask you difficult questions. These are, you're in front of the United States Supreme Court. You're not going to get any higher. The court is less interested, if you will, in the facts of your case as they are in the principles.
Or defining hearsay.
Whatever it would be. The principles of law that are at issue, they took your case because of the principles of law, not because your client was harmed that's not why they took the case. So you need to always keep that in mind. This is the last rung on the ladder. And so you need this real case. Think about the implications of everything that you're arguing, because whatever we decide is going to affect thousands of cases all over the country with different facts. So you really sort of need to think where it is that you're going with this thing and what it is that you want us to do. And if you take a position that you see that the court is having difficulty with, you need to get out of that. Because once you lose the court on a matter, especially one where they think the court thinks that you're not prepared or you're disingenuous or whatever the reason is, you probably will never get them back, ever. So it's really important that when these are real cases, that you have thought about before you ever step foot in that courtroom, all the implications of where your argument is taking them. Actually, I think I'm done. Thank you. I enjoyed it very much so.
Oh, okay. I'm going to say that I echo everything that has already been said. I think that both sides were really impressive in your presentation and how you address the court. I do think it's really important to take those signals from the court because they are trying to move along with what you're trying to say and literally see which side has the better case in terms of merit. But if you take the court to a place where they can't help you because of how you're arguing, just be very, very careful of that. But I have to say, by and large, both sides did an excellent job of laying out what your arguments are. But just be careful, listen to the questions and see if you can make a compromise and not be too rigid. If you're too rigid, you're not giving the court any room to sort of adopt your position. But otherwise, both of you did excellent jobs. I commend you both, and congratulations on getting this far. JB, go ahead.
I'm just gonna stand because I can't see you guys. I echo everything that's been said. First and foremost, I just wanted to commend you all and everyone that took part in this competition. As many of you have heard the spiel, Moot Court has been instrumental for me, and I fully believe that the program provides each of us that are willing to take the endeavor with a lot of practical and soft skills that will help you exceed in the field. So the fact that you're all here on a Sunday doing this, just to be commended at the least. I thought you all had a great cadence, good respect for the court. There were times that some of you got a little bit informal, which is fine in trial when you're trying to appeal to a jury, but when you're speaking to a court of appeal, especially the Supreme Court, everything should be very formal and very matter of fact, so to speak. Just quickly, I thought the petitioners did a good job. Specifically, I think it was Jordyn, you said, if I don't understand your question correctly, if I understand your question correctly, you're asking this, which is a fantastic procedural way to avoid saying, I don't understand it. Can you repeat it or rephrase? So I thought that was good. Lindsay, I thought you had a good roadmap in your cadence. As Judge Gam mentioned, I was just cautioning to limit your argument to the issues, which I know is easier said than done. As far as responded, Sully, I thought you did a good job. I've had the pleasure of seeing you before, so I thought I saw a good sort of looking for progression since the last time that I saw you. So I thought that was great. I would just be careful with tailoring your remarks very specifically to the questions that are asked. It's always good to sort of support your answer with your argument so that you can get back to what you want to argue. It's really important that you're specifically answering it. Otherwise, you're just going to get it thrown again at you and it's going to kind of just lag your time. But other than that, I thought you were very clear in telling us, we're here to discuss this issue and these are my arguments. So I thought you were clear in that regard. Alyssa, I thought you were great. I thought that you really were not flustered and we were really peppering you with questions and you really came back very matter of fact and very, no, Your Honor, yes, Your Honor, this is my position. Now, the merits of the positions, of course, are debatable and they're difficult, but half of it is presenting it to the court with the confidence that you're correct. Because if you don't have that, then even if you are right, it doesn't seem right. So great job on that. And I thought for the most part, all of you were very respectful of your opponent's time. I always try to look and see what the other attorneys are doing when one side is presenting. So I didn't see anything that should be mentioned, but it's always very important to be respectful of your friend on the other side, as they say in this court, and to always be have good demeanor with the court. So great job, and glad to see you guys are all here.
So I don't want to take too much time. I echo everything that everyone on this panel or bench said. There's some things I do want to point out because I think all of you are 2L. So if you choose to compete again for report or for the IM, I think it's important to know. But I also want to point out both Sully and Jordyn how great it is that both of you participate in both advocacy groups and are just able to switch from trial to this, and it's just so much talent, right? I mean, I couldn't do that, and I really congratulate you both for trying out and making it onto Moot Court and also doing so well. So I think that's something to commend because you guys are, it's just awesome to see because that's always my biggest concern, right? How do you switch your tone of voice, your demeanor from trial to this? It's hard, and you guys just did an excellent job. So I'll just start since you guys are on my left side. Sully, I enjoyed hearing you. I think you're just so confident up there. And it's, even if your arguments aren't, I'm not saying they were, I'm saying even if they weren't strong, you're just such a strong advocate that you can really convince a court to rule with your side. The only part that lost me was the question that three of us asked you, and the answer was the same every time. And I think you got a softball at one point, and maybe at the moment you didn't understand it, but I think that was the only part that I guess I would have said slow down and just try and listen because it was asked 3 times, and the answer was basically given to you by Judge Gam. But other than that, I mean, amazing job, Alyssa. In terms of demeanor, I think you were my favorite there. It was a little fast for me in the beginning, but just the way you were speaking, I was like, nothing's gonna rattle you. So great job with that. Again, the only thing that lost me was the same thing Judge Gam said, was the particularity point, or the point about him already being labeled as a murderer. That's the part that kind of threw me off. I got lost there. But in terms of the technicalities and formalities of moot court, I mean, you did great. So great job, guys. I mean, I'm just so impressed and so happy, right, that you were able to make it this far. Jordyn, great job transitioning. You have this thing where you transition to an answer, and then you use a case to support it, and that's great, right? Because I don't want to hear what you're saying. I want to hear what the cases are saying, and the fact that you bring up these cases to support every point you said was my favorite part. That's so important in moot court because we want to know what the case law is, how it applies to our facts. The transitions were great. Eye contact was really good for everyone, by the way. The eye contact was very great because I know we have a chief justice, but the other justices also like to get eye contact and feel respected on the bench. But great job overall. And Lindsay as well. I would only say that if this is a close problem, we got to know all the cases, I think, in the problem at least. So when I think JB brought up the case of Best, you had a good answer because you said, I don't know, Your Honor, not like that, more formally, but you switched to another one right away. But I know this is a close problem, so I would want you to know every case if you're not required to do so much other outside research, right? So that's the only thing I would say. Other than that, great job. I'm very proud of all of you, so thank you. So, Judge,
All right, so again, congratulations to all of you. I look forward to helping you with the moot court season moving on. You are all very talented. And the winner of this day, today, goes to the petitioners.
Congratulations.
Thank you.
Thank you.
You want to stand and take a picture?
Sure.
Good job.
Oh, that's not bad.
Really good for the live stream.
I did it with the panel too. I think you guys have done that. Just you guys have already requested pictures. I have.
We should probably put down the.
Who wants to post them on the 17th Circuit website?
Congrats. So proud of you.
Thank you.
Oh, I should have mentioned this, but Demas is giving artworks for you guys.
Oh yeah, congratulations.
Oh.
Yeah, I should have said that.
Yeah,
in there as well.
congratulations.
So I want to picture a lot more of you too.
Yeah,
Like,
let's
eventually,
get
like
the.
panel, the final round.
Yeah, I know.
So let's get one picture with the winners and the bench.
Please, and you guys before me.
Oh, wonderful, thank you. Everybody smile. 1, 2, 3.
Where you going, your eyes are shining.
Oh, thank you.
All right, now let's see what the runners up to. I mean, but everybody together. Everybody in bus please. Yeah,
Come on.
Let's do
Just, yeah, just.
And then
Oh, you guys can be.
all right, everybody look.
Alyssa, come here.
Oh, boy. I'm sure we're lost into that,
We're scooting this one.
1, 2, 3. Sorry, I have kids.
Thank Thank you very much.
Oh, it's my turn. Congratulations. If you guys don't go into litigation, seriously, I will come directly out.
We're gonna do one more with the best player as well.
Congrats. That's just something I put your desk. We're just gonna take a picture with the best breed.
Oh,
as well. And
you can, thank you.
this is just a lot. So I'm just
Thank you, thank you.
wow, good looking group.
Right?
Wow, you guys all look so nice.
I don't know where to look.
Where do we look?
Thank you, you too. Well, thank you for having me. That was awesome. It's my pleasure.
Thank you so much, I enjoyed it.
Yeah, thank you so much. I mean, thank you for also putting so much effort into feedback and all that. It's very important.
No,
Thank
that's
you.
good, that's
Thanks for having me. That was we can
Next time.